All right, hello and welcome to this Assange defense panel, an expert reaction panel reacting to today's news from the British High Court regarding Julian Assange's extradition proceedings. There's good news and bad news. The good news is that Julian is not on a plane today to be extradited to the United States, but we'll hear some details about the bad news. Basically, we have convened a panel of reporters and lawyers to talk about, who have been covering these proceedings for years now, to talk about today's ruling, what it means in the larger context, and then what's next. So first, we're going to hear from Kevin Gosztola and Chip Gibbons, who have been reporting on this for Shadowproof and for Jacobin, respectively. And then we're going to hear from Marjorie Cohn, a past president of the National Lawyers Guild, and then from constitutional lawyer and author Stephen Rohde. So, Kevin, could we start with you? Could you just talk about, basically just give us a summary of the ruling, what happened today?
Yeah, so the summary of the ruling, and thank you for having me. As Nathan says, I have done reporting for a long time. I'm doing it right now over at the dissenter.org. There's more to cover in detail and what we'll get into here today. But the basics are that the UK High Court of Justice has given the United States government a way out of this mess on a silver platter by basically saying, here are the words that you can say to us, and you can avoid an appeal from Julian Assange and move forward with extradition. They actually tell them explicitly in their ruling what to say. So just tell us that you will allow him to not be exposed to the death penalty, and then it'll be all right. Tell us that he will have the First Amendment rights that are usually afforded to every single US citizen when they are put on trial, and then you will be able to have this extradition. And so that's crucial, because we already had this happen when it comes to assurances. We already saw how easy it was for the US State Department to go to the UK Foreign Office and state that the relationship between the UK and the US government was a priority. We do not want the Assange extradition to cause tension between us as allies. And so treat what we are doing in good faith, recognize that we are mindful of your human rights concerns and that we will address them. And they made assurances about how he would be treated in US prisons while he was under pretrial detention, how he would or would not receive mental health treatment, and how he could apply for a transfer to his home country of Australia. There were loopholes in almost every single assurance that was offered, but those were treated as evidence. They were taken seriously by the High Court of Justice, and they said there was no reason to doubt those assurances, even though they were not part of the original extradition proceedings, the main extradition proceedings in September 2020. And so now here we are again. We are going to I know it's dancing around the issues, not really dealing with what's at the core of this case, but people need to understand what we are seeing is a repeat of an episode that we already lived through, that Assange already lived through multiple years ago now. It's been over 2 years since the appeal was quashed effectively by the US government, just saying, oh, we promise not to abuse Julian Assange, and just said the things that they knew the UK High Court of Justice wanted to hear. So it's astounding. That's the way Stella Assange put it outside the High Court of Justice. And I would agree with her that it is astounding that you can put forward a defective extradition request that raises all of these human rights concerns, and all the UK High Court of Justice asks of the requesting state is that you just say some magic words and then it will all be fine with the court. I hesitate to believe that this would be a standard that would be applied to any country other than the United States. I don't think any other country trying to request somebody for extradition would be able to do this and get away with it. Now, that said, there are two basic details I want to mention before throwing it over for others to, and I'm sure they'll have some specific legal discussion that I'm just going to avoid because I don't have the expertise and knowledge that my co-panelists do. But they said that they're not going to allow fresh evidence from the Yahoo News report related to the alleged CIA plot to kidnap or kill Julian Assange. This has been a really important aspect of the case. I want to tell you that this is kind of an alarming part of the decision, and I'm going to give it more attention tomorrow in a report that I'm putting together. But for this conversation, people need to recognize that the Yahoo News report had some discussion about this idea that Julian Assange was going to be spirited out of the Ecuador embassy and was going to go to Russia and become a diplomat on behalf of Russia. And that was in the Yahoo News report. Now, we know from Aitor Martinez and some other people who have worked with the Assange legal team that this was false, that this is not true, that they were never trying to give or confer Julian Assange diplomatic status so that he could actually leave the Ecuador embassy. They were never going to do that with Russia. The idea was maybe Bolivia or Venezuela or some other Latin American country that was willing to challenge the United States. But it was not going to be Russia because they were mindful of what was happening politically in the United States around the 2016 election, and they didn't want to cause a problem. But that being said, this was in the district court's decision, and they referenced a CNN report that was filled with, I think, scurrilous and unproven allegations about Julian Assange trying to set up the Ecuador embassy as some kind of election meddling outpost. But Judge Vanessa Barretzer used this to justify all of the surveillance, all of the targeting that the CIA was doing to Julian Assange. And that's in this decision. In this High Court of Justice decision, they are saying that all of the allegations about the CIA, while they are serious, they don't say that they're not unproven. They say we take them seriously. But we don't believe any of that is connected to the extradition proceedings. We believe that it is connected to the fact that the US government thought Julian Assange was going to flee to Russia. And now, and this is where it gets incredible to me, now that he is in Belmarsh and they are trying to extradite him to the United States, there is no threat of rendition or kidnapping or him being killed anymore because he is not going to go to Russia. That's what it says. So everyone should take this as a bittersweet moment. Julian Assange is not going to be extradited, but there is a lot in this decision that is troubling.
Thank you so much, Kevin. I mentioned shadowproof. That's how long you've been doing this. You've been covering this for years now, and you're now writing for The Dissenter. So thanks for that correction. Thank you for that. And so let's turn now to Chip Gibbons. Chip, you've been taking a more in-depth look at the judgment. Do you want to talk about the grounds for permission to appeal, which were denied, and which ones were accepted?
Yeah, and let me just start by saying I agree with Kevin that this is a bittersweet day. Any day in which Julian Assange is granted more time and another opportunity to fight for his life, fight to return to his family, and fight for the First Amendment and press freedom rights of all of us is at that very level a good day. But there is extremely a lot of stuff in this decision to be concerned with. They say they granted the appeal on 3 grounds: political expression under the European Convention on Human Rights. I'm going to get to that in a minute. The unfair prejudicial treatment as a foreign national, and the third part is the death penalty issue. So basically what happened was Gordon Kronberg, and anyone who's listened to me or read my writings knows how much I love Gordon Kronberg as a human being. He was involved in many racially biased prosecutions against Muslims. He called Daniel Hale a heroin dealer. The fact that he almost sabotaged the US's extradition request brings me some sort of schadenfreude today, I guess. I don't know if I should say that, but I did. But he made this declaration where he was outlining the types of arguments the defense could raise and the types of arguments the prosecution could raise in response to them. And he said, and this was so foolish of him to say in writing in a sworn declaration, but I'm glad he did, that the US could potentially, he didn't say they would, might raise the argument as a foreign national that Julian Assange does not have First Amendment rights. Now, this is fascinating because they are saying the Espionage Act extraterritorially applies to a foreign national, but the protections from it do not extraterritorially apply. Well, it wouldn't be extraterritorial at that point. We'd be in a US courtroom. And, you know, you have this prospect of having the press freedom trial of the century that could set a precedent, right? Chilling press, not just in the US, but globally. And they're saying, well, maybe we won't let him do the press freedom thing. Maybe we'll say he has no press freedom rights he can bring. I mean, that is a horrific prospect. And a couple of questions, if I get into the weeds a bit, because you and I have both seen these questions, a lot of people are asking, well, what First Amendment rights are there under the Espionage Act? Because there is no public interest defense. The public interest defense is different than the First Amendment issue. A statute can be challenged on constitutional grounds via two types of challenges. One is a facial challenge, which says the statute as a whole is unconstitutional. The other is an as-applied challenge, which would be to say, as applied, this statute is unconstitutional in this case. Whether or not the Espionage Act permits a public interest defense, the attorneys can raise either of those charges. And I assume they probably will raise at least one of them, maybe both of them. And then the other issue is that the Supreme Court has been very clear that in order to criminalize pure speech, you have to prove specific intent. This is why perjury, fraud, stealing value from veterans all has a specific intent requirement for deception. And this has been applied to the Espionage Act in a case in the 1940s about a very unpleasant anti-Semite who sent anti-Semitic literature in the mail, but who the Supreme Court overturned his decision, overturned his conviction based on the First Amendment, saying they didn't apply the right intent standard. So there isn't a First Amendment defense he can take to the jury, but they will have chances to argue the charges can't be applied to him, argue about what level of intent can be applied to him, as well as this is going to be a huge fight when it comes to jury instructions. And I think a lot of lay people don't understand how important the battle over the jury instructions are, but that will influence that. So they were basically saying Assange had none of those rights. Or they might say that because he's a foreign national. And the UK court said, no, he can appeal on those grounds, and he can appeal on the death penalty grounds. Now, it's very unlikely that Assange would ever face the death penalty in the US. I recognize that as a US civil liberties advocate, my job is to tell people all the things the government can't do. His lawyers in an extradition is to tell them all the things they can do. And it's not a frivolous argument, and what I would have made it if I was them, but it's a very remote possibility. But sitting in this courtroom, the UK prosecutor said Assange's charges could be changed to death penalty charges. There's nothing you can do about it, UK, and we have to approve the extradition, even though the law says we can't. So he's been granted appeal rights around the foreign nationals not having the same rights and not having political expression rights issue, as well as the death penalty issue. Now, the UK court has said if the US gives assurances that it will grant him the same rights as an American citizen, and that doesn't mean they're going to grant him robust First Amendment rights or First Amendment protections. They just can't, to quote a judge, they just can't treat him any worse than they would an American. And they've treated some Americans pretty badly. And then the other points where they were denied was the issues around the political offenses exception. International law traditionally prohibits extradition on a political offense. The Assange defense team always says espionage is a textbook example of a political offense. Against my better judgment, I went to law school. I took a class on political offenses, and guess what the textbook example of political offense was? Espionage. So that is not just a euphemistic language. It is quite literally the offense in the textbook. They denied appeal grounds on that. And then the rest of the free expression grounds, the arguments that prosecuting Assange for exposing U.S. war crimes, as well as the arguments that Chelsea Manning is a whistleblower, and under European law, Manning would be considered a whistleblower, and that would prohibit Assange's prosecution. They reject it. So the big things we think of with the political expression arguments, he is not allowed to appeal on. So again, while I am happy Julian is not on a plane, and I am happy he will have another venue and avenue to fight this. The UK courts are once again closing their eyes and refusing to acknowledge this is a case about persecuting a journalist for exposing US war crimes with grave political freedom, journalistic freedom ramifications under US law, under UK extradition law, under European law, and under international human rights law. Just totally blinding their eyes to it. And the fact that they have essentially telegraphed to the US like what you have to do to squash this appeal is shocking to me. And if I'm being really cynical, and I don't know if I should be cynical on this call, but I will be. I mean, it reads to me like they were ready to rubber stamp the persecution of a journalist for exposing war crimes, but Gordon Kromberg and the UK prosecutors just messed up so badly with these self-inflicted wounds and unforced errors around the death penalty and around that ridiculous statement about the government might argue that a foreign national doesn't have a First Amendment right, that the courts had no choice but to temporarily halt it and say, hey, US government, here's how you can fix this. So I'm not optimistic going forward, but I am happy that we have a temporary reprieve.
Thank you so much, Chip. Appreciate that rundown. So the government is arguing that he'll get a fair trial, that he won't get the death penalty, that it's not a politicized case. Marjorie Cohn, can you tell us what you make of those arguments and what you think the US is going to be filing in response?
Yes, Nathan. Well, the death penalty issue is a really important issue, I think. And it was clear during the hearing in the High Court that the judges were concerned about that. The European Convention on Human Rights protects the right to life. And UK law says, and particularly the Espionage Act, that if a person is extradited and could be charged with the death penalty, in other words, the death penalty will be imposed, or if it's imposed, it will not be carried out, then that person cannot be extradited. And so what the court is asking is that the US provide assurances that Julian Assange will not be charged with the death penalty, and if charged with the death penalty, it will not be imposed. There would be a hearing on these so-called assurances by the United States. And the test at that hearing in May would be whether or not the government has provided, the US government has provided satisfactory assurances, in other words, to the satisfaction of the appeals court judges, that Julian Assange will not be charged with the death penalty or it will not be imposed. And there is a provision called specialty in Section 95 of the UK Espionage Act, which says that a person who is extradited can only be tried on those offenses for which he is extradited, not other offenses. And so that would, if he was charged with, for example, aiding and abetting treason or espionage, even though he's charged under the Espionage Act, he's not really charged with committing espionage. But if he were, the charges were amended to include those new charges which do carry the death penalty, then it would violate those U.S. assurances. And we saw already that after the district court judge denied extradition because Julian Assange would be treated inhumanely in U.S. prisons, then the U.S. at the 11th hour came forward with these so-called assurances saying, oh no, he won't be sent to a supermax prison. He won't be in isolation unless somebody at the Board of Prisons decides for some subjective reason, which is non-reviewable, that he can be held in those conditions. And so there are cases, particularly a case from Spain, where the United States gave specific assurances, and those and then the person was extradited from Spain to the United States, and then the U.S. Backtracked on those assurances. So I think that it is going to be difficult for the United States to give airtight assurances that Julian Assange will be able to mount a First Amendment free expression defense, that he does have a right to free expression, and that he will not be charged with the death penalty offense, particularly on the latter point, because the Supreme Court in 2020 held that it is long settled as a matter of American constitutional law that foreign citizens outside the United States territory do not possess rights under the U.S. Constitution. That's the U.S. Supreme Court. So how is the U.S. government, the Department of so-called Justice, going to come forward here and say, well, yes, he will get First Amendment rights? So I think there is a tremendous room for argument, assuming that the judges rather, in the UK hearing in May, if it gets that far, if Biden doesn't decide at the last minute to offer a plea bargain, so he won't be embarrassed if and when Julian Assange is extradited to the US in the middle of Biden's campaign, that it's not an open and shut thing. I mean, I must admit that I agree that when I first read this decision by the High Court, I thought, oh my gosh, they've given the Department of Justice an out. But I'm not so sure that that out is so airtight, and so it's not over till it's over.
Thank you, Marjorie. And let's bring in Stephen Rohde, a 50-year constitutional lawyer. And what do you think of that question? What do you think about so the U.S. has to promise the UK court that they're going to treat Julian right if he's sent here. What do you think the UK court should make of those arguments if there is a hearing in May?
Well, I think today is a very dark day for freedom of expression in the world. I think Gabriel Shipton, Julian's brother, captured it, that this court has put Julian Assange in purgatory. They have created what I believe could be a hopeless trail going forward. And I think it perpetuates much of the travesty that this case stands for since it was first initiated. It's important to understand the essence of the ruling, that of the 9 grounds that Julian Assange and his lawyers sought to have further appellate review in the UK courts, these 2 judges of the High Court have denied any appellate review on 6 of those grounds, and they have offered conditional review on the 3 of those grounds that my colleagues have discussed. The United States government, meaning the executive branch of the government, has time to make those assurances. And then on May 20, there will be a further hearing at which Julian Assange's attorneys will be able to challenge whether those are substantial assurances. There is a kind of naivete in this ruling. It's 66 pages, but the British can be very loquacious, but get nowhere in what they are saying. And I do urge people watching this webinar, you can go to the site, you can go to Assange Defense. There is a summary of the decision in press release that the court has issued, which is quite explicit in clarifying what the court did. The naivete comes from a failure of the British High Court to understand the American system of separation of powers. The High Court acts as if the U.S. government, the Department of Justice, as Kevin says, express and utter certain magic words, then Julian is denied his right to further appellate review of even those 3 grounds, and with those assurances, he will be extradited to the United States to stand trial. The problem is that while I believe the executive department can give an assurance not to seek the death penalty, the executive branch cannot assure the British court, Julian, or anyone else that his First Amendment rights will be protected in the United States. That's because it will eventually be the judiciary responsibility to analyze the Espionage Act and to consider what, if any, First Amendment rights Julian Assange says and has. Now, there's been some ground on this already, and it's not good. In a case called U.S. versus Morrison in the federal district court in 1988, the court, now they were dealing with a government insider in that case, not with a publisher as in our case, but it's certainly not a good precedent. The Fourth Circuit said there that the First Amendment may not be used either to enable the government employee to excuse his act of theft or to excuse him from his contractual obligations. In other cases, including Morrison, proof of laudable motives cannot be introduced, and they are irrelevant. We know that recently an attempt to make a case for this kind of public interest by Daniel Hale was also rejected, and he was sentenced to a brutal sentence in jail. So I'm worried that whatever the United States government tells the High Court does not understand the limits of what the executive branch can represent, and we don't know what will happen if he is extradited and if his First Amendment rights to challenge the Espionage Act, and Chip is correct, he can challenge the face of the statute. The fact that a statute doesn't say you have a public interest defense, that doesn't supersede the overall challenge to that statute on First Amendment grounds. But there's no guarantee that that will prevail, and therefore this assurance of protecting his First Amendment rights are illusory. I want to add that in addition to everything my colleagues have said, there is one further remedy, and that is the European Court of Human Rights. Julian and his lawyers have to decide whether now or after May 20, if the High Court accepts these assurances and orders his conditional extradition, the Assange team will have the opportunity to appeal to the European Court of Human Rights. That court has Rule 39, under which it can issue a stay of execution, a stay of extradition in this case, to ensure that Julian is not whisked away from England on a U.S. military jet while these legal proceedings are pending. I think this court has made it worse for the UK and the United States, and may have teed up this case for review by the European Court of Human Rights. That court in Article 10 protects freedom of expression. For the lawyers among us and those who look at details, Section 2 of Article 10 has a troubling catch-all of grounds on which freedom of expression can be limited and restricted. That Section 2 is a problem, and it's going to have to be argued and addressed. And also Article 3 would prevent the use of the death penalty, or beyond that, torture or inhumane conditions, which the trial judge in Britain said the incarceration of Julian Assange presents a serious risk. So there would be a lot for the European Court of Human Rights to consider. I believe that the naivete of the High Court today is alarming. It cast aside the serious questions of political offense, that Julian is being prosecuted for his political opinions. It is so cursory in this respect that it is an appalling analysis by what one would consider well-trained and educated judges. So we are in a limbo. I agree with Chip that any day that Julian is not on that military transport flying to Alexandria, Virginia, is a good day. Tragically, however, he remains at Belmarsh Prison in difficult health conditions. There's never been a reason why he is not free to be with Stella and his children, even pending appeal under any supervision that would take his passport and retain him within the confines of the UK. It's never been adequate why this man is wallowing in prison, weakening his health and his life. And I would hope that one step in that direction would be to ask for his release pending appeal. I'm very grateful that we're gathered today so immediately after this decision. You're going to see a lot of commentary. I have a piece coming out in Truthdig. I will bet $100 that Marjorie has a draft of an article on her computer as we speak. Kevin has already issued his initial reactions, and I'm sure we'll hear from Chip and others. The importance for the audience is to know, as Stella and his brother have called for, is that this is even a greater moment for vigilance and response. We need to move the resolution through the House of Representatives and eventually the Senate, calling on Joe Biden to drop this prosecution. We need to rally in our towns, in front of our public libraries, and in front of the offices of the United States government. We need to write to our congresspersons and senators and to Merrick Garland and Joe Biden. Today only highlights what a travesty this case is. It should renew our intentions to protect the individual Julian Assange and to protect the broader principles of freedom of the press.
Thank you so much, Stephen. I'll just note that resolution in the House of Representatives is HR 934. There's more information about it at assangedefense.org and how you can call your representative to urge them to sign on to it. It has 9 co-sponsors already. Steve, you and Chip both mentioned Daniel Hale, and I'll ask Chip actually to come back to Daniel Hale's prison conditions in a little bit, if we could talk about that. But first, we actually have a question from Daniel Hale in the chat. This is a drone whistleblower just released from from prison after enduring brutal conditions at the Communications Management Unit in FC Marion in Illinois. And he asks how long this whole process is going to go. And so I'm wondering, Kevin, if you might be able to just give us the bigger picture. If there is an appeal hearing, how long might that appeal process play out? And if not, what are we looking at next?
All right. Well, thank you, Daniel, for your question, and hope everything's going well for you on home confinement. I hesitate to act like I understand the UK appeals court system or the UK judiciary when I am not a UK legal expert, but let me just invoke the experience I have following this for the last 5 years and say that it would seem to me that if you look at the ruling, it says on May 20th, there will be a hearing on these assurances, which I think it's fair to say will be proffered. My colleagues have raised a fair issue, which is perhaps the US government can't assure the court that Julian Assange will have First Amendment rights in a trial. But then that would be dealt with during this May 20 hearing, I would expect. And the reason why, and perhaps that will persuade the High Court to approach this differently. I don't know that we're going to get to an appeal hearing necessarily yet. But I think it's an open question, and others who are in the UK, I hope that they'll step forward and shed some light on this process, because as someone who lives in a country that freed itself from a monarchy, I usually look at this system where people are still wearing wigs and pledging their allegiance to His Majesty and find it a little bit baffling. But I think that this would be something that we would see develop over the next several months. If those assurances do not end the extradition process for Julian Assange in the UK legal court system, then we are going to probably have something on the calendar in September or October, I would imagine. That would be an appeal hearing. And it would be limited, but I would expect that it would be a 1 or 2 day hearing. I don't know how long they would need, though, because it's only on those two very limited areas that we talked about, the First Amendment and then on the death penalty. And then after that, of course, if he doesn't prevail, he's going to be able to apply for a review from the European Court of Human Rights. I'm a little bit unsure of what happens after that. Someone else here can jump in, but if the United States were to lose, it would seem to me it has to go to the UK Supreme Court, where the US government will have a shot at challenging the UK High Court of Justice's decision. And so that extends this again. And so whatever you think about this, I don't see how Julian Assange gets put on a plane this year. But what is troubling to me is the thought that maybe we wouldn't be able to stop the US government from putting him on a plane before a European Court of Human Justice review or whatever was completed. And also if they immediately say that they are not going to take up this issue, then we have a problem. Let me just say, generally speaking, because this may be the last time I get a chance to comment, I'm going to have to leave here at the top of the hour. But let me just say very specifically to what everyone said, that the freedom of the press issues are crucial to this, and they should not be lost in all of our conversation. As we get into the weeds, it's up to us to continue to make those the central question and to put those two people, and we need to force the US lawmakers out there to engage with this in a way that parliamentarians in Europe have already been doing. There are some in the UK, numerous lawmakers in Australia, in Assange's home country. It's essential that they pay attention to this, but it'll only happen if we do the work to make it a political issue. So, I think it was easier in Australia to make it a political issue because Assange is an Australian citizen. But this is about our rights. This is about all of our rights. What's going to happen to Julian Assange will define how journalists are treated and how people who engage in these general acts of journalism or freedom of expression might be treated going forward. So that's the thing we need to communicate. I mean, it is about the person. It always is about Julian Assange and what he's gone through and the injustice that he is suffering. But beyond that, it's also about us. And it's also about making sure that people realize what they are doing in establishing a precedent that is going to impact us all going forward collectively.
Thank you so much for joining us, Kevin. Really appreciate that. I will turn now to Chip, and Chip, feel free if you'd like to comment on the state of current U.S. politicians' support for Assange, as Kevin mentions, the European and Australian delegations and groups in support of Assange. But I was also thinking that you've covered the case of Daniel Hale, and his case is relevant here. He was assured that he would get certain treatment and then was placed in a CMU. Is that the kind of double dealing that Assange could face?
Yeah, so the judge ruled that he should be, I don't remember the specifics, and it's strange talking about you, Daniel, when you're in the audience. But this happens to me a lot. That he should be in a facility with, I believe, some sort of mental health treatment, and instead the Bureau of Prisons overruled that and sent him to a communications management unit, which has been called Guantanamo North. It's a very harsh unit where people's communications with the outside world are restricted. On the subject of the First Amendment guarantees, though, or assurances, my interpretation of them might be different than other folks on the panel. My understanding is they don't have to assure that the courts would grant Assange robust First Amendment freedoms, but they just would not have to deny them on the basis that he's not a U.S. citizen. So there's this really awful opinion I had to read in law school about Pregnancy Discrimination Act, with Justice Richard Posner said, the Pregnancy Discrimination Act doesn't mean you have to treat pregnant women well. You can treat them as worse as you do everyone else. And I do think the First Amendment thing is a really low bar for the U.S. government. They don't have to assure, and this is my reading, I could be wrong, that Assange will be guaranteed the First Amendment applies here. They don't have to assure he has news gathering privileges. All they have to assure is that the U.S. government won't argue to deny him rights based on not being a U.S. citizen. And they could say, okay, we're giving you the same rights to give a U.S. citizen, and that's zero rights. And that would meet the letter of the assurance. And I don't think it would actually displease the UK High Court based on today's decision, which was very dismissive of press freedom. Members of Congress in the U.S. are speaking on this issue, and I'm not going to name names, but I know a number of offices have staffers who are watching this presentation right now. So there is interest in the U.S. Congress. It's growing. It's not as large as it should be. Almost 1 year ago, April 19th, we saw Rashida Tlaib lead the first congressional letter, all signed by progressive Democrats who are part of what's called the Expanded Squad. And it was a very powerful letter to Garland. More recently, we saw Jim McGovern and Thomas Macy lead a bipartisan, bicameral letter to Biden. It had all of the original signatories of the Tlaib letter, plus some additional Democrats, including Jayapal, who is chair of the Congressional Progressive Caucus, as well as Republicans as well. So we see this sort of growing awareness within the Congress. And I go up on the Hill frequently. And, in the last 5 years, I think the attitudes have changed somewhat, that there are a lot of people on the Hill and the staff positions who may not share my view that Julian Assange is one of the greatest journalists of the 21st century. In fact, they might not like him at all, but they are horrified by what the ACLU and the New York Times are saying is the press freedom ramification. And I do know they're talking to their bosses. And I do know even in offices we haven't convinced yet, they're helping us behind the scenes to move things forward. So I do think that Congress is a terrain of struggle. And I do think if we put pressure as constituents, we can actually get somewhere with this. And Biden's going to have to notice if a huge block in the Congress is calling for them to drop these charges. And I would point out that the estimates we've heard from people on the Hill about how many people you would need to actually get Biden to pay attention, they're not as high as you might think. They're higher than where we are right now, but it's not like 400 or 100. It's much lower. So I would call your member of Congress if they've already signed one of the letters and are on the resolution, thank them. It's important to contact people when they've done the right thing. We do this thing sometimes as activists, as we love to contact people when they've done the wrong thing. And then when they're doing the right thing, we don't contact them. You've got to do both. I understand the impulse. And then if your member's not on it, call them up, tell them to get on it, find like-minded people in your community, and ask to meet with them in their in-district office. And I can give you what types of things to share of them: the New York Times letter, the UN statements, the civil society letters. Leave them with a packet of this information. I also have advice on talking points, like what to say. Don't cover this topic. If the staffer takes the conversation off rails, here's how you get back on the rails. And if people reach out to info@rightsanddissent.org, I'm happy to provide those resources for you.
Great. Thank you so much, Chip. Oh, yeah, Stephen, Rohde, do you want to add to that before I come back to Marjorie for a final question?
I want to build on that because there was a high government official in the United States government who last April said that journalism is not a crime. That was Joe Biden at the White House Correspondents' Dinner on April 29, 2023. He said it in the context of the detention of Evan Gershkovich of the Wall Street Journal in Russia. And what is Evan charged with? Espionage. And we are highly critical of his detention and prosecution, as we should be, as the entire world should be. But the hypocrisy of the Biden administration is glaring. To get on his high horse at the Correspondents' Dinner saying that journalism is not a crime, and to have voluntarily perpetuated the persecution and prosecution of Julian Assange, when upon taking office, the Biden administration and its Justice Department could have accepted the lower court ruling, which had denied extradition, essentially on humanitarian grounds. Instead, the Biden administration has vigorously prosecuted Assange ever since. So those are the kinds of points you can make when you contact your legislators to ask for nothing less than fairness and equal treatment, and that the charges against Assange should be dismissed. There was a question in the chat about lack of jurisdiction if Assange is brought to the United States. The U.S., and this was touched on by either Kevin or Chip, the U.S. takes the inconsistent position that the Espionage Act of 1917 has extraterritorial reach around the world, that any journalist can be indicted, extradited, and prosecuted in the United States under the Espionage Act, but simultaneously they don't have First Amendment rights in the United States under the U.S. Constitution. So the government argues that if they seize him and bring him to the United States, they have jurisdiction over him. I'm sure that'll be one of the challenges to dismiss that indictment. But on those legal issues, it's equally important for the public to react to this continuing travesty.
Thank you so much, Stephen. And Marjorie Cohn, I wanted to bring you into with maybe a final question as we approach our 60-minute mark shortly. But somebody asked in the chat just about Julian, and Stephen mentioned that another day that Julian does not mean that Julian is not extradited is unfortunately another day Julian is in prison. Is there any hope of a bail application or anything like that, or does this mean he's going to be in prison for this appeal process?
Well, judging from the way that the court has behaved so far, I think they would deny bail pending appeal. I'm sure that Julian's lawyers will make that argument, but they go back to the time that he had asylum in the Ecuadorian embassy in London and was charged with a misdemeanor of failure to appear, which he was actually sentenced to a year. One of those years that he has been in the Belmarsh prison. So I think that that decision will be that argument will be raised, but I don't think that it will be accepted. And I do want to say one thing. I think I disagree with Chip that the First Amendment freedom of expression argument only has to do with Julian Assange being treated equally to the same as a U.S. citizen, and that's kind of a low bar. I think it is a separate issue that he has a right to freedom of expression. That's the way that the court listed the issues as two different issues. And along those lines, Steve was talking about what Biden could have done, which is just dismiss the extradition request, dismiss the indictment once the lower court judge in the UK found that there was a high likelihood that if Julian were extradited, he would be at risk of suicide because of the harsh conditions in which he would be held. One of the things that is important is that in this 66-page decision, the High Court did cite the Julian's argument about Barack Obama considering, and Barack Obama, by the way, indicted more whistleblowers under the Espionage Act than all prior administrations combined, but his administration refused to indict Julian Assange because of what is referred to as the New York Times problem, because WikiLeaks did exactly what the New York Times, Der Spiegel, Le Monde did, and The Guardian, which is to publish classified information, publish government secrets. And one of the defense positions that was quoted by the High Court in this decision is that there was no prosecution under the Obama administration because it was still thought wrong to prosecute the media for either receiving or publishing state secrets from a government official. And listen to this. Yet the principled and consistent stand taken under the Obama administration, and that included Joe Biden as vice president, the principled and consistent stand taken under the Obama administration was reversed under the present Trump administration from early 2017 onwards. And so what Joe Biden has done is to continue what Trump has done and not take the position that his good friend Barack took, which is that you cannot punish a publisher of information such as Julian Assange, WikiLeaks, because you would have to do the same to the New York Times. And that is in the decision. They did cite that.
Thank you, Marjorie. So we're approaching our 60 minutes here. I know, Kevin, you have to leave shortly. Do you want to deliver any parting remarks here?
Well, I would just thank everyone for joining to follow what's going on with Assange's extradition. I would also just quickly mention that our friend Daniel was spared. Obama did not indict him, even though the Justice Department didn't indict him, even though they raided his house and could have put him on trial during his second term, but didn't want to invite more attention to drone warfare, it would seem, through prosecuting a whistleblower. So they didn't close the case, much like they didn't close the investigation into WikiLeaks and Julian Assange, but they punted. And then, we're in this position because we have an unprincipled Justice Department that basically handles these kind of political cases against whistleblowers and journalists in the same manner. And that is, if you inherit them as an administration, you do not shut them down because you do not want to be seen as being a political wing of the US government. I think that's what they would say. So, it's bizarre. We've seen spokespeople for the White House say things like, they think they're better than Donald Trump's Justice Department because they haven't closed this investigation or case into Julian Assange, that they haven't dropped the charges against Julian Assange. They act like shutting it down would be what Donald Trump would do because he politicized the Justice Department. And they maintain that they have not politicized the Justice Department. And I would just say that that's a very disastrous way of excusing and not taking responsibility for what you are doing. You are the captain of the ship, so to speak. You are responsible for this right now. Anything that Donald Trump has done is in the past. Now Biden owns this, as Stephen made clear. Most of what's happened in the extradition case since Baraitser ruled against it, since the district court ruled against extradition, has been with Joe Biden at the helm. So it is on Democrats and it is on Joe Biden to end this. And that's what we're all here today to do, to make this an issue and to keep appealing to people in Congress and the media to take this as seriously as it is. So thank you, everyone.
Thanks so much, Kevin. And again, you can find Kevin's work at the Dissenter. And then we'll just get some final remarks from our other panelists. Chip, do you want to say something before we close?
Point something out that is 100% correct, that the Trump administration revived the Assange and Hale indictments and Biden saw them through, and that the position of the Department of Justice is always, we don't get rid of the last administration's cases. But there is one exception under the Espionage Act of this happening, and this is the AIPAC lobbyists who are indicted under the Espionage Act under George W. Bush, which many people thought was an abuse of the Espionage Act and triggered a big sort of First Amendment concerns about the act. And the Obama administration dismissed the charges against the AIPAC lobbyists. They did not dismiss the charges against the government employee who shared information with them. The Obama administration gave a very technical reason for why they did this. They said that the district court had raised the level of intent for the non-government employees, and they couldn't prevail under that level of intent. But there are plenty of people within the Justice Department who talked anonymously to the media who said, this is purely a political decision. And I have never once in my entire life, Nathan, met someone who thought the AIPAC dismissal under the Espionage Act was about law and not about some type of politics. Not once. Maybe I will. Maybe someday I'll meet Eric Holder and he'll assure me of this. So not only is there a precedent in the Obama administration, of which Joe Biden was part of not bringing Espionage Act prosecutions against journalists. And Obama had the worst record on the Espionage Act of anyone before him. There's also a precedent of dropping the previous administration's abuse of the Espionage Act about hiding it behind highly technical legal grounds. So I would say both of those things. I would say that this is an incredibly dismal time for press freedom. We are witnessing the worst failures of media since the Iraq War. And in the midst of it, they are seeking to imprison the guy who did good reporting during the last war. And it is not lost on me that as we are seeing these repeats of the mistake of the Iraq War from the US media and from US journalists, they are trying to put someone in jail for telling the truth about the Iraq War.
Nathan, I just want to use
Chip. Sure, just a second. Chip is the policy director at Defending Rights and Dissent. You can find them at rightsanddissent.org. Yeah, we'll have closing remarks from Stephen and then Marjorie.
I just want to use my last few moments. I recommended all of the writings of the other panelists that you've seen today, but I want to lift up an extraordinary book, A Century of Repression, The Espionage Act and Freedom of the Press by Ralph Engelman and Carrie Schenkman. This is a beautiful work of history, of law, of policy, and pulls a lot of what we're talking about together and has a section on Julian Assange. That is the kind of material that's out there. The Julian Assange website has additional material. Every person listening here needs to educate themselves, needs to mobilize and organize to end this prosecution.
Thank you, Stephen. Again, Stephen's going to have a column forthcoming at Truthdig on the Assange case. And we'll just hear lastly from Marjorie Cohn.
Yes, I just wanted to remind people that 5 media outlets last year wrote a letter to Merrick Garland saying, drop the Espionage Act charges, and that included the New York Times, The Guardian, Der Spiegel, Le Monde, etc., who had also published so-called Cablegate, which is the nefarious things that the US government is doing. And I don't want people to lose sight of the fact that the reason that Julian Assange is being prosecuted is because of WikiLeaks revelations of war crimes by the US government in Iraq, Afghanistan, and this decision from the High Court also cited the so-called collateral murder video, which shows, and they talked about how US Army personnel were discussing how great it was that this helicopter aimed at civilians in Baghdad and killed 11 civilians, including 2 Reuters journalists. That's one of the notorious war crimes, but many others that WikiLeaks revealed. So yes, there are all these other legal issues, but I think we can't lose sight of the fact that the reason that Julian Assange is being charged is because WikiLeaks revealed evidence of US war crimes.
Thank you so much, Marjorie. And Marjorie writes a column at Truthout, so check out her writing there. She's covering this case extensively. Thank you so much to all of our panelists. Thank you to the supporters who are watching. Thank you for following along. Again, we are Assange Defense at assangedefense.org. Thanks so much. Take care. Bye-bye.